So while we... I'm joking, Minister. This is the first time. All right, we'll get straight into it. I'm conscious that this is the first time FASEA has appeared before the committee. I suspect you've probably got an opening statement, Mr. Glenfield.
I do, a short one.
Can we try and keep it as narrow as we can? We are obviously a bit short of time this evening.
Indeed.
But please go ahead and welcome.
Great, thank you, Chair. Just by way of opening comment...
On name and rank as well.
Name and rank, Stephen Glenfield, Chief Executive Officer. You can tell I'm new here today. Look, but by way of opening comment, I think because it is FASEA's first visit to Senate estimates, I thought it's opportune just to reflect on FASEA's role and just to highlight the progress that we made to date in a fairly short period of time before we have discussions. In April 2017, the Corporations Amendment Professional Standards for Financial Advisors Act set the education, training and ethical standards of licensed financial advisors in Australia. The magnitude of implementing industry-wide higher educational training and ethical requirements we believe requires a universal effort to meet what is a demanding set of challenges. Just as the advice industry has made or is making the necessary adjustments to legislated change, FASEA's efforts are being targeted at bringing the legislative requirements to life. Over the next 5 years, we expect the combined effort to deliver significant benefits and build important signposts to consumers that the industry has been on a journey towards becoming a trusted profession. Equally importantly, consumers of financial advice are set to gain fresh perspective and clarity on the important role of financial advice in their lives. By its statutory nature, FASEA's work is clearly laid out. The design and subsequent obligations of the Corporations Amendment Act 2017 are quite clear. The amendment makes changes to the Corporations Act to raise the education, training and ethical standards of financial advisors by requiring relevant providers to hold a degree or higher or equivalent qualification, to pass an exam, to undertake a professional year, to undertake continuous professional development and comply with the Code of Ethics. Transitional arrangements exist for existing advisors and are reflected in the work of FASEA. FASEA's task is to bring to life that professional standards framework of the legislation. This means our role is to approve bachelor or higher degrees or equivalent qualifications, to approve an exam, to set requirements for continuing work and training or the professional year, as you would better note, set requirements specify a word or expression to refer to a provisional relevant provider, make a code of ethics and respond to applications for foreign qualifications. To date, FASEA has worked hard to develop and release a standards framework that we consider is balanced, workable and which draws upon a process of allied consultation. With those standards now legislated and released, FASEA continues working hard with industry stakeholders to deliver on those higher education and ethical standards. In doing so, we are keenly conscious of the need to recognise the qualifications and study already undertaken by existing advisors and to set exams that we consider are fair to all advisors. In assessing the long-term impact of the reforms, it's important to consider what this will look like after it beds down. After the implementation of the FASEA reforms, consumers will be able to approach an advisor in the knowledge that that advisor has achieved a minimum education level to enter or have stayed in the profession. And if it's a new advisor, they'll know they will have completed a professional year under the guidance of an experienced practitioner. Consumers will understand that their prospective advisor has passed an industry-wide examination, verifying that advisor's ability to apply their knowledge of relevant law, ethics and understanding of client needs to real-life scenarios. They will also be aware that the advisor is regularly refreshing their technical, regulatory, client care, professional and ethical knowledge through their commitment to continuing professional development. Consumers will recognise that they're dealing with an advisor with a high standard of technical and practical knowledge, bound by a legislated code of ethics comprising principles and core values which commit the advisor to a high standard of consumer service by addressing values of competence, diligence, fairness, trust and honesty, and that ensures that the advisor provides appropriate, informed advice in the consumer's best interests. All of this, we consider, will increase consumer confidence that their advisor is providing them with a professional service, fulfilling their expectations in the same way that they would expect to receive from professional counsel from, say, their lawyer, accountant or doctor. Thank you.
Thank you, Mr Glenfield. Deputy Chair.
Thank you, Chair. So, Mr Glenfield, just to look at some of the logistics in this sector, how many people are in the sector? Is it 200,000 people?
Well, in terms of the relevant providers that we are setting our legislation around, it's around about 25,000.
25,000. But is there a community up to 200,000 in the financial advisory sector? I mean, I've had representation on this and they say this affects businesses which employ about 200,000 people.
I don't have those numbers, but...
So anyway, 25,000 registered financial planners?
Correct.
And they may employ people. Is that the...
That is correct, yes.
Yeah, okay. So your timetable and upskilling of this sector has been delayed by another 12 months, is that correct?
There are proposals to change the requirement for existing advisors to comply with the exam and with their educational requirement, but they're not yet legislated.
And has that been driven by an examination of the logistics or...?
That was a decision by government.
Okay, so the government's made the decision and you just go along with it. Given that some of the participants in this sector have been about for 170 years, are you actually saying that there is a lack of due diligence, honesty, truthfulness in all in the sector?
From a FASEA viewpoint, we are charged with discharging the legislation. The legislation came about due to a number of reviews and Royal Commission and other inquiries. Our role within it is really setting the standards.
Okay. So you're going to set a standard, and you finished off those that assessment of those standards as akin to doctors and lawyers and the like. I think the problem is people don't pay for financial advice in the way that you pay for a medical specialist or a doctor or a lawyer.
It's putting in terms of moving towards a profession acting to serve the interests of those that they are advising, in a similar way that you expect other professions to serve the people that they are dealing with.
I think other professions would like to be paid the way financial advisors get paid. Senator going.
Let's try and
Well,
stick
Previously speaking.
to estimates.
a 3,000 plus upfront fee for a financial plan. Have you got any indication of how much that is prevalent in the sector at the moment?
No, I don't. FASEA's role, as I said, is dealing with writing the standards.
Okay. So, how many staff do you have to carry out the task that you're on?
We have 10 staff.
10.
Correct.
So what is the logistics of 10 staff versus 25,000 financial planners? Do you devise curriculum and put it online, or how does it actually work?
No, so it depends on what we're looking at. So in terms of the exam, we have the responsibility for design and implementation of the exam. We're using a provider to assist with that, but we set exams for advisors that are currently running quarterly and will run bi-monthly next year. We have a role in approving our higher education providers' degrees as being bachelor or higher level or equivalent to meet the education standard. We have the role to approve foreign qualifications for those advisors who got their degree or higher overseas to assess the equivalence of that against Australian degrees. And on top of that, we set the standards for CPD PY.
Okay, now is it true that the final version of the legislated professional standard was released only days before professionals in that industry are required to comply?
To which standard are you referring?
The legislated professional standard.
There are about 7 standards.
Well, all 7 or
Yeah,
one
okay,
of them?
No. So the standards were consulted on twice throughout 2018 and then registered at varying timeframes towards the end of 2018 into 2019. In terms of timeframes for compliance, I guess the major compliance was the Code of Ethics for 1st of January 2020. The code was registered in February of 2019.
Look, notwithstanding the good work that you're embarked upon, are you aware that there are sections or sectors of the industry who make representations in this parliament that there is extreme angst amongst financial planners about their future viability, in fact their current mental health, so to speak? Does that get fed back into your department?
I am aware of those, but again, for FASEA, our role is setting those standards.
Okay.
We aren't the supervisor.
So, go back to is there a suggestion there'll be a delay in these standards being enacted?
No, the standards are all in place today.
Okay. So do you think the original time period of 5 years is sufficient to meet the FASEA educational standards?
In terms of for existing advisors with that time frame, the maximum education an existing advisor needs to do is a graduate diploma, which is 8 subjects. Generally on a part-time basis, that can be done over 2 years, but I am aware of stakeholder view that it is a tight time frame, and I've been aware of that since I joined FASEA, and I think that's probably reflected in some of the discussion that's going on today around the time frame.
Okay. So is it possible that there might be consumer detriment in the period to 2026 because we won't have enough qualified financial advisors?
Look, the evidence we're getting to date, the first major hurdle or major step for the advisors is completion of the exam, which currently has a deadline for the end of next year, but they're considering a further year. To date, we've had over 5,000 advisors either sit or register for the exam, so that's over 20% of the industry have already put their hands up to carry on. So to that extent, advisors are, in my view, pushing forward.
They've been pushing for it for a long time. Just quietly.
So
I said pushing forward to do the exam and
5,000 out of the 25,000.
Over the first period, the June exam remains open, so I expect that number will rise somewhat more. And we're offering the exam 6 times next year to take people through.
So where you get to say 10,000, would that be enough to meet the to make sure there was no consumer detriment? That people just couldn't get advice?
Again, that's outside of my ambit.
Senator, we would assume that the vast majority of financial advisors of that 25,000 would sit that exam within the time frame, but we realise that it was tight, and which is why the government has announced a policy to extend the time by which advisors can sit the exam by 1 year.
Was there any consideration of compassionate grounds, illness, missing a deadline in respect to the 2 years? Or is it just do it, get a licence or you don't?
The way the legislation is written, you must pass the exam within the time frame.
Okay. No compassionate reason or anything would get you...
You are able to come back again through the new entrant to do it, but FASEA doesn't have a power under the legislation to grant such exemption.
So what does the code monitoring position mean? The government has recently announced that it will not implement the requirement that financial advisors participate in a compliance scheme that monitors their compliance with the FASEA Code of Ethics. What does all that mean?
So the legislation as it's written had FASEA promulgating a Code of Ethics that would take effect from the 1st of January next year, with a view that that would be monitored by code monitoring bodies going forward. The government announced recently that they were looking to look at that in the context of the single disciplinary body. What that means from the 1st of January 2020 is that the code remains law and advisors must comply with it, and licensees will have a responsibility to oversight their advisors' compliance, and you would expect, I think, that the disciplinary body would have some role going forward, but that remains unclear.
So is it true that the guidelines for the FASEA Code of Ethics were only issued on 18th of October 2019?
So that's those. We released a practical guide for how to interpret them on that date. We previously released with the Code of Ethics itself, when it was released in February 2019, an explanatory statement, which also included guidance and case studies on how to interpret. There was a desire from stakeholders to have further guidance, which we have released a version of on the date you said.
Okay. So I presume this FASEA Code of Ethics is disclosure, act in the best interest of the client. Is there any
It contains 5 values and 12 standards.
What's the 5 values?
The values are off the top of my head. So it's trust, trustworthiness, diligence, and I will quote properly. Sorry, I just didn't want to quote wrong. Okay. The 5 values, as I said, trustworthiness, competence, honesty, fairness and diligence. So
I would imagine they would have been apparent in most financial advisors for a very long time. That is just a new code of ethics.
It's a code of ethics for advisors going forward.
So, given the delay in the publication of the guidelines and the code of ethics, is it reasonable to expect financial advisors in compliance scheme from 1st of January 2020, given the delay in publishing the guideline and code of ethics? I mean, are you worried about that, or is it?
No, the guidelines are there to help interpretation. The actual code of ethics itself, I think, stands up well on its own with its interpretation of what those values are and the standards to be there. It's a guide to ethical conduct of advisors.
So you don't think it's an unreasonable timetable that you've set, or is it
I don't
is it contested
consider so.
by the industry that it's unreasonable?
I don't consider it is for ethical behaviour, and it's been consulted on, as I said, throughout 2018 twice. It's been well known what's in there since it was promulgated.
Do you expect there to be a dramatic improvement given the decision to introduce this code of ethics, or do you think it's just going to be business as usual with those who moved early to get into the scheme?
No, I think if you look at the totality, as I said in the opening statement, of what FASEA is seeking to implement through the legislation, which is a lifting of standards. And that's what the aim of the legislation is.
So the standards you're seeking to list, notwithstanding the media out of the Royal Commission, are you saying that the financial advisory sector was bereft of standards?
Yes.
Well, you may well say that, Senator Wish-Wilson.
Well, you
but
weren't
there are
on
plenty
any of the- you weren't on any of the
plenty of
inquiries
reputable
last
people
10
in the
years.
financial advisory sector.
Order.
Again,
Mr. Glenfield.
I come back to FASEA's role is to implement a legislation that it's been given.
Yeah, and so you haven't gone and made an assessment of the need
No,
for it,
that-
you just undertake a task given to you.
Correct.
Fine, thank you.
So, Senator Wish-Wilson, you had a question?
Yeah, I just wanted to know, are there groups out there that support an exam and the industry becoming more professional?
There are, yes.
Yep. So my understanding is that there's been discussions for nearly 10 years now about a national exam. ASIC's been consulting on this for a number of years. There have been people knocking on our doors recently trying to slow things up. Could I ask you about the actual exam itself?
Mm-hmm.
What did you model the exam on? Did you use any international examples?
So in setting the exam, it's been based on 3 areas, so 3 practical areas that you would expect an advisor to know. So those 3 areas are around their legal and regulatory obligations. It's around ethical behaviour and how you apply ethical behaviour, and it's around understanding your client.
Okay.
Which are 3 things that we will consider that a well-performing advisor would know well and be able to execute.
So how long is the exam?
The exam is 3.5 hours.
Okay. I did my Series 7 and Series 63 in the US nearly 10 years ago. They were 6-hour exams.
Yep.
Most people failed them 2 or 3 times before they passed. The US has had a series of exams to provide financial planners in the industry that level of professionalism for a number of years. Why has it taken so long to get a national exam in Australia on this industry, considering some of our overseas counterparts, who we trade with regularly, have had these kind of exams in place now for decades?
Again, I'm not in a position to comment.
Could it be lobby groups that are still lobbying lobbying our officers right now to slow these things
I
down?
think that's, the official can't answer that.
Right, okay.
Okay.
Well, could I just ask though, did you, in terms of your resources for the exam, have you worked with other agencies, like Securities Institute of Australia and other groups to pull these things together?
We have used an exam provider who does a number of similar exams around the country and is very experienced in what they do.
Okay.
Senator Stoker.
Thank you, Chair. Evening.
Evening.
The explanatory memorandum for the Corporations Amendment Professional Standards of Financial Advisors Bill shows that that bill contemplated that FASEA would take into account diploma or degree courses, licensee training courses or CPD. It's a direct quote from the EM. However, FASEA hasn't taken into account diploma courses, licensee courses or CPD in the way that it has approached its task in recent times. Why not?
I don't consider that's correct. In setting the education standards, we look at the Corporations Act requirement, which is that an advisor must reach a bachelor level or higher or equivalent. What we've said for existing advisors in recognition of their time in the industry is that rather than doing a 24-course bachelor degree, a recognition of the work you've done is that the most you will need to do is a graduate diploma, which is at 8 courses. We have then done a series of work around accreditation of pre-existing degrees that advisors have done. So that's looking back over time to degrees that are applicable to the advice sector, and we've sought to benchmark them against our curriculum and approve them. So we've approved, I think, all up around about 130 odd degrees to date. So if you're an advisor who's done one of those approved degrees, you're only going to do a Code of Ethics course. For those who don't have that, we wrote to each of the industry associations to ask what courses they run for their advisors and to benchmark those courses at bachelor level or higher. And to the extent that an advisor has done one of those that passes that bachelor level or higher, they get recognition of prior learning. So if you look at things like the FPA courses, the AFA courses, there are 2 credits of RPL given into the graduate diploma. So instead of doing 8, you get 2 credit before you go in. We've also done reviews of advanced diplomas in the advice space and given credit. We've done reviews of Securities Institute old courses that a lot of the stockbroking department have done and given credit for that. So we've recognised their continuing professional development where you can benchmark it at bachelor level or higher.
The EM discussed experience in the industry and stated that FASEA could take into account the fact that an advisor who has been in the industry for a longer period of time has completed more CPD courses in giving them recognition of prior learning. However, FASEA hasn't taken into account, as far as I can tell, correct me if I'm wrong, the number of CPD courses that have been completed by an advisor and is not recognising CPD courses as distinct from formal diplomas or degrees that have been completed by advisors when deciding how many units of a formal degree or diploma that they need to complete in order to keep practising into the future. Why not?
So again, to the extent that we have permitted to do a graduate diploma, that's a move from a 24 course to an 8 course, which is recognition of work they've done in the industry to get there. Again, the legislation itself talks about bachelor level or higher. The great difficulty with CPD is it varies. There's no record for us of what's been done at bachelor level or higher. What we've said is where we can demonstrate it, we will recognise it, and we continue to do so as meeting the requirement of legislation as to the standard of that education.
So how many CPD courses have you accepted as reaching that standard?
So as I said, what we've looked at to date is study for getting an industry designation or an association designation, that would form part of your CPD. So having joined the industry, you continue your professional development through doing this additional study. So to the extent that people have applied to us at bachelor level and above, we have reviewed and approved where appropriate.
I don't think that answered my question. So how many of those industry-run CPD courses
Yep.
have you ticked off as counting towards these accreditations?
I can sort of add the other of my head. I won't be quoted exact number, but it is around about the 8 mark, Helen.
Did you say 8?
Yeah.
It is open to you to take it on notice.
Yeah,
if
I
you-
will actually, I will take that on notice to give you the proper number.
And in particular, I'm interested in knowing how many of those are backward-looking so that they are meaningfully giving recognition for prior CPD. So if you
Yep.
could break it down into how many are recent and how many are backward-looking, that would be something I would
Yeah,
find
we can take notice, but I will confirm that most of them are backward-looking because
Okay.
these are for existing advisors who have already done the study.
Good. Does FASEA acknowledge the risk of losing an awful lot of experienced financial advisors for whom doing a full 8-subject graduate diploma late in their careers is just too much, too expensive, and quite frankly, too disrespectful to the role they play in the culture of the profession?
Same questions as Labor. Wonder where they came from.
What? Please.
Senator
Could you answer the
Whitwell,
question, please?
Sorry,
Again,
late
Might
in
be
the
a
evening.
coincidence.
FASEA's role is implementing legislation that came from Parliament. We
That doesn't
don't.
answer the question. Do you recognise the impact is to push experienced financial advisors out of the profession?
I don't have evidence that that is or isn't the case.
Okay. Well, the number of advisors on the financial advisor register has decreased from nearly 29,000 at the start of this year to around 25,500 as at the beginning of October. This, I would suggest, is a significant drop that we can expect to see continue to decline over the next year or so as what I would suggest is an unreasonable approach to valuing CPD and industry experience kicks in. So tell me, is it not the case that the profession is losing around 6.4% of financial advisors a quarter?
I don't have those figures. And
Take it on notice,
I'll
perhaps?
take that on notice.
How many new advisors have joined the profession this year?
Again, I don't have those figures. I'd have to take that on notice.
All right. How many new advisors sat the June 2019 exam?
None.
No.
No advisors. No
That's
new
correct. 0 new advisors sat the exam. I think that tells us something about what this is doing to the profession. Not
Well, the
only
standards were too low in the first
Senator
place.
This isn't your opportunity.
Senator
No,
Whitwell,
I'm
The-
allowed to interject from time to time.
the
no, you're not. That's disorderly.
It is
the
disorderly.
the approach that is being taken by FASEA is squeezing the experience, the grey hair, for want of a better term, the people who can provide experienced, well-considered, context-driven advice to those who are young and coming through the profession. And
Senator
it
Stoker,
seems 0 new ones are joining the
please try
profession.
and stick to questions rather than commentary.
Okay, I think that's fair. No problems. Perhaps I can give you some case studies by way of example. You said that there's no prejudice to older members of the profession by the requirements FASEA is imposing. I'll give you the example of 3 advisors, each of which have more than 30 years of experience in the profession, who have been leading it, teaching others, mentoring others as they come through to be, wise and fair and working in the interests of customers. Paul Franklin is 72 and he wants to continue to practice for another 8 years. He's been told he needs to do a full 8-unit diploma to continue. James Ford is 64. He would be required to do the full 8-subject graduate diploma. And Wayne Leggett is 64, has a bachelor's degree and an 8-subject diploma of financial planning and would need to do 5 subjects, all with over 30 years experience in the profession. can I suggest that the approach that is being adopted by FASEA is not sufficiently recognising the service, experience and prior learning of people who are at the upper end of the profession?
I would only respond that the legislation requires, as part of the lifting of the standards that it was aiming to achieve, that advisors reach a bachelor or higher level of education.
Except that FASEA has declined to meaningfully value much of the way that this profession learned, practiced that learning, developed that learning for all time until recently.
They're trying to change a culture. That's the whole point.
Senator
They're trying to change a
You'll
culture.
have your
You're
opportunity
in
later.
history that's been malfunctioning for so long.
Order.
That's the point.
I'll move on to
Can
something
we
else.
please get back to questions?
On Feb 11, as you know, FASEA released the Financial Advisor Code of Ethics a week after the release of the Royal Commission final report. In November 2018, FASEA consulted on a draft Standard 3 that provided you must not advise, refer or act in any other manner if you would deprive inappropriate personal advantage for doing so. Perfectly reasonable. Don't dispute it, of course. But the final version, which was not consulted on, included a different Standard 3, which said you must not advise, refer or act in any other manner where you have a conflict of interest or duty.
Yes?
The revised guidance, released on the 18th of October, clarified this again to make it clear that an advisor can refer where they may be conflicted to an unconflicted advisor. The reference to conflicts in the context of referrals refers to payments for giving or receiving a referral, which is a significant departure, I'd suggest, from the second version. Was FASEA influenced by the Royal Commissioner's views on conflicted remuneration in this process?
No.
Did FASEA consult with ASIC on Standard 3? And if so, what did they say?
No, FASEA conducted a broad consultation on the Code of Ethics and received large numbers of consultation around Standard 3, many of which were requesting a better clarity of the words for what was intended by Standard 3, and FASEA settled on the wording as it appears in the standard now.
Can you see that the second version is completely impractical?
It's not, we don't believe it is.
Commissions on life insurance financial advice is the internationally usual payment mechanism. And not even Commissioner Hayne made a blanket recommendation to ban life insurance commissions. But commissions of any form are generally accepted as a form of conflict of interest. Corporations Act requires the approach to be the management of conflicts of interest and good disclosure, for instance, rather than their complete avoidance. Because let's face it, conflicts of interest exist in all parts of
Have you got a
life.
question?
Yeah, I do.
Why don't you get to it then?
Order.
Thank you.
Stop giving us a lecture on
Senator
what we've been
Wilson.
for the last 10 years.
Under the new guidance,
Oh, I beg your pardon?
under
Why don't you guys, share
Let's
notes?
try and get through this as
You'll
quickly
have
as we
your
can.
chance. Under the new guidance from the 18th of October, Example 5 on pages 15 and 16 refers to a conflict arising from commissions from insurance products. Is this intended to be a blanket ban on an advisor acting where they receive commissions for life insurance products?
No, if you read the preamble to Standard 3, it makes it clear that FASEA is not banning any particular form of remuneration, but it makes it clear that the remuneration must meet the provisions of the code, which would include being in the best interests of the client, representing fair value under Standard 7, and in accordance with the other provisions of the code. There is no blanket ban on any particular form of remuneration.
And how do you understand the receipt of a commission by an advisor to be something in the interests of a client?
In thinking through the standard itself, so the code applies between the advisor and the client, and in going through, if you look at Standard 7 in terms of your fees and costs, it's important to demonstrate that those fees and costs are fair to the client, they're reasonable for the service that is being provided.
I understand the fair and reasonable part.
So in terms of setting your commission, does that commission fairly represent the cost of providing the service? And is the service you're providing and the advice you're giving in the best interest of the client?
So the advice needs to be in the best interest of the client,
It needs the
but
code,
the fee just needs to be fair and reasonable.
the Code of Ethics is read in totality. So you need to meet each of the provisions of the code in dealing with your client.
So on what day of the week would the provision of advice that is in the best interest of the client for a fair and reasonable sum, but that ultimately resulted in money going into the pocket of an advisor in the form of a commission, ever be? How can the payment of that commission be something in the interest of the client?
Well, in looking at the service that you're providing, there is nothing in the code that says that you shouldn't be paid for a service that you provide, but that service that you're providing, you're being paid for, should be fair.
But that's
Now,
a different
if you've
test. That's a different test. You've said
value.
three things. You've said first, in the interest of the client, then you've said fair, then you've said reasonable. I tick off and I accept and I agree with you entirely on fair and reasonable. I'm trying to understand what different thing you mean by in the interest of the client.
So it's talking about the advice itself being in the interest of the client for whatever product you're recommending.
The advice has to be in the interest of
Yeah,
the client.
correct.
But the payment of the commission being in the interest of the client. Do
But
you
the-
say
the-
the
the
payment
stamp-
of the commission has to be in the interest of the client?
What I'm saying is that the code highlights in the preamble to section 3 that if there's anything in that payment that you would reasonably say is inducing you to act in a manner that's not in the interest of the client, then you have a conflict and you shouldn't act. So if that commission is is in a fashion that is inducing you to do something, sell a product that is not in the interest of the client, then you have a conflict and you shouldn't act.
Okay. Well, it strikes me that there is very little intellectual separation or clarity on what you mean by any of those things.
I think
I'll wrap it up.
We just really need to keep to questions.
That's okay. You said FASEA's conducted a number of consultations. Was one of them with ASIC?
ASIC made submissions on all of our standards that we put out for consultation.
So that's a yes?
Yes.
What did they say?
I don't recall off the top of my head.
You take that on notice?
Take it on notice.
The reason I ask is that I couldn't find that submission in any publicly available place. Am I wrong about that? Are they publicly available?
I'll take that on notice too.
Well, perhaps you can take this question, assuming I'm right, because I think I am.
Oh, of course you
Why? Well, if I'm wrong, they'll correct me.
Senator Wish-Wilson.
Why hasn't-
Not assisting.
Why hasn't FASEA released any of the submissions they received throughout their consultation exercises?
Look, I will take that on notice.
Thank you very much.
Thank you.
Okay, is that it for FASEA? You go with our thanks.
Thank you very much.
The no rent seekers are still alive and well in this
And
place.
we will move on immediately to
Hey, you haven't spent 10 years.
APRA. Hopefully we can do a
Someone's been knocking on
pretty rapid changeover.
We are
Order.
sanctimony. Thank you, Mr. Chair. I appreciate it.
That's okay. We're very tight now. Okay. We're still live. If you want me to suspend, I will.
I do appreciate it.
It's okay.
Perhaps my stepping out will help everyone calm down.